Okay, you're ready to go. Have a good show.
Well, hello, everybody. I'm Whit Blanton, the president-elect of APA Florida. We're going to get started in just one moment. Let everybody have a chance to get logged in. I'm still showing we're about 2 minutes till 12, so we'll wait till 12 on the nose. 1 minute. Okay, I am showing 12 noon on the spot, so let's go ahead and get started. Welcome everybody to our 2022 legislative session wrap-up overview. My name is Whit Blanton. I'm the president-elect of APA Florida and chair of the Legislative and Policy Committee, and it's my pleasure to be here with you today with a really great panel of experts. Joining me today are Lester Abberger, who is our advocate in Tallahassee. He's with Florida Lobby Associates. And also Alex Magee, who is our great executive director, who's really been helping pull all the material together in concert with Lester that we send out to our members on legislative issues that matter to planners in the planning profession. And we have a special guest with us today, an old colleague of mine, Thomas Hawkins, who is an AICP member. He's a lawyer. He's affiliated with U.S. Department of Urban Regional Planning. And Thomas is the author of Land Use Law in Florida. So he is going to be available for questions and answers, particularly around potential implementation aspects of some of the legislation that we're going to be covering today. So thank you all for joining us. I'd also like to thank our annual sponsors, Theriac in Spain, AARP Florida, SNME, Plus Urbia, Wade Trim, and the Corradina Group. We couldn't do this without their support. So APA Florida is very active among state chapters in the legislative platform. We have a legislative and policy committee that has really been great at being hands-on on the job and providing a lot of great feedback to us as we develop our legislative platform and as we review bills during the session. That committee is comprised of one representative from each of our sections across the state and at-large representatives. And if anybody out there is ever interested in serving, please let us know, and we would be glad to consider appointing you to the Legislative and Policy Committee. Some of the things that the committee helps with and what we do for our members is to produce a bill tracking report, legislative reporters that are sent out apprising people of developments in the legislature, particularly during session, but leading up to and following session as well. We had our second annual Planners Month in the districts in 2021. And then every year we host a public policy workshop, most recently back in February of this year. It was virtual. Maybe at some point we'll go back to an in-person public policy workshop, but the virtual format allows for a lot greater participation, and people seem to like avoiding that 4.5 or 5 hour or whatever drive to Tallahassee. Let's go on to the next slide. One of the other areas where you can be engaged in our legislative advocacy is by joining the Planners Advocacy Network. That is a national organization across states, and it focuses not only on Washington, D.C. and some of the legislation and policy matters that happen between the presidential administration and Congress, but it also pulls together a grassroots coalition across state lines because, as you know, many of the legislation affecting the states are being shopped around to all the different states by different organizations. And so we can learn from how other states have dealt with some of these issues. That includes access to tips, training, and different advocacy tools, including speaking with the media, speaking with your legislators. It allows you to have cheaper registration to APA events, including the National Policy and Advocacy Conference that happens in Washington each year.
Wait, I think we skipped a slide.
Oh, we did. Oh, yeah. Okay, well, back to APA Florida for just a second. I mentioned the Planners Month in the districts, where the Legislative Committee helped us put together a legislative priority and flyer that we distributed to our legislators. And we had several meetings across the state where we were able to talk about issues that were important to planners and the planning profession. And you can see an image of that flyer here. A lot of it related to issues of local authority, local control, and advocacy for some key issues such as housing affordability, preservation of the environment, and transportation funding. The Legislative Committee will soon begin to work on the 2023 platform. That committee will meet in the next few weeks, and we'll start to identify the legislative priorities that we will then use for additional advocacy. And what we've learned is that we're all about trying to build partnerships and interject into the process early before we even get to session, before we even get to the organizational session, so that we can start developing a relationship with our legislative members. That's why we have the Planners Month in the districts, because it's a little more comfortable and casual meeting in the districts than trying to pin people down during session. Okay, so I'm going to turn it over to Lester to talk about what happened and give us a summary of some of the activities. Lester?
Thank you, Whit. I really appreciate it. And just to elaborate a little bit on what Whit just explained, under his leadership and the leadership of President Wyatt Bowers, we developed what I would call a short list of legislative priorities this year. As you can see, there's some almost 3,700 bills filed. We follow, as you'll see in subsequent presentations, 300 or 400 of those. But we thought, and our leadership team and the members of the Legislative Committee thought that if we could narrow down the priorities a little bit, that it will enable us to engage more effectively. So just briefly, we supported full funding for affordable housing, which came in at about $365 million, the highest ever. We supported the ability of local governments to enact smoking bans on beaches and in parks. We supported a wetlands inventory that will help the state deal with resiliency issues, among others. We supported all of those bills passed. We supported a Glades Protection Act bill that was stalled in committee, and we supported the funding for Florida Forever at $100 million. So a good record on the things we supported. Of course, a lot of things we identified as things that we would oppose. One was a cap on public transit funding out of the State Transportation Fund. That bill, the bill that passed was stripped of that, so we were successful on that. We opposed the short-term vacation rental bill, which did not pass. We opposed what we felt was a terrible impact fee bill, which did not pass. We opposed provisions in a school concurrency bill that were later stripped out. And we opposed the wetlands mitigation banking bill. So a pretty good record on our priorities. The other unusual thing about the 2022 session, it was what's known as a reapportionment session. These happen once every 10 years based on population growth between 2010 and 2020. And it required the legislature to redraw all of the state's congressional districts, state Senate districts, and state House districts. And they're redrawn, as I said, to reflect that population growth. Florida grew from 18.5 million residents in 2010 to 21.5 million residents in 2020, which resulted, because of our population growth and loss of population in other states, this resulted in Florida receiving a new congressional district. So we now have 28 districts. The preliminary maps for the state House and state Senate districts were adopted in early February. They were conveyed to the state Supreme Court for review, and the court approved those districts. The congressional district situation is a bit more complicated, as those of you maybe who follow the news over the past couple of days know. Each Florida congressional district will have about 770,000 residents. The House and Senate adopted their plans, and those were forwarded to the governor yesterday, and the governor promptly vetoed the House and Senate plans, and in an unprecedented fashion presented his own plan for reapportionment. The DeSantis plan would result, if you look at based on 2020 election results, the DeSantis plan would have 20 Republican seats and 8 Democrat seats. The House plan had 18 Republican seats and 10 Democrat seats, and the Senate plan had 16 Republican seats and 12 Democrat seats. So the governor has vetoed the legislature's congressional appropriation reapportionment plan, and the legislature will reconvene in special session between April 19th and April 22nd to try to reach some accommodation with the governor with respect to the congressional reapportionment plan. As we've talked about before, and as the slide shows, the budget is the only must-pass bill. It came in at $112.1 billion, which is a 10% increase over the, as the slide shows, the $101.5 billion current budget. The state is experiencing a robust economic recovery, which boosted the general revenue collections. And then also there was some $3.5 billion that was unspent from the $10 billion the state received under the American Rescue Plan of 2021. They used the federal funds, the $3.5 million, for a number of what they described as one-off projects, including some $358 million for land acquisition, $100 million for water storage south of Lake Okeechobee, $50 million for the governor's job growth grant fund, and $20 million for new state airplanes. The budget also allocated an additional $8 billion to the state's reserves, which is very prudent. The main categories of spending, as usual, are health and human services, largely the state's Medicaid program, education. There was an increase of $8,000 in per pupil spending, which came to about $384 million. The Department of Transportation was well funded at $12.7 billion, environmental and natural resources at $7 billion, the state university system at about $6 billion, Department of Corrections at almost $4 billion, and as I said, some $8 billion moved to reserves. The Legislature also adopted a $650 million tax cut package, mostly in the form of sales tax holidays, excuse me, most of which we're familiar with. 1 week disaster preparedness, 1 week back to school, 1 month in July for the purchase of energy efficient appliances, a 1 year sales tax exemption for diapers, and a permanent reduction from 6 to 3% in the mobile home sales tax. And a priority of the governors, the legislature adopted a gasoline sales tax holiday the month of October of this year, coincidentally right before the election, and that is a $200 million tax cut. Other budget highlights, state employees received a well-deserved 5.38% pay increase. There was no increase in state university system and state college tuition. Again, historic levels of funding for affordable housing. Visit Florida was funded at $50 billion and extended for 6 years. I would expect there'll be at least $1 billion worth of vetoes, largely in member projects. The budget has not yet been forwarded to the governor, but when it is, he'll have a couple of weeks to work on it. And as I say, I expect we'll see at least $1 billion of vetoes. He vetoed $1.5 billion in the 2021-22 budget. The session was also characterized by what are known as the culture wars, and the legislature jumped right in, adopted a strict 15-week ban standard for abortions. The parental rights and education bill was passed, the so-called Don't Say Gay bill, and the Wrongs Against Our Kids and Employers, or the so-called Stop Woke Act, was adopted. Couple of other issues of import, like most Florida governors, Governor DeSantis is frustrated with the diffused authority that he shares with the elected members of the cabinet, and he urged the legislature to adopt a bill that basically gives him sole authority to appoint the directors of the Department of Environmental Protection, the Department of Veterans Affairs, and the Florida Department of Law Enforcement, and the legislature passed that bill. There were 11 gun control measures introduced by Democrats. None were heard, even in one committee. Other issues that were not addressed and could be the subject of further special sessions include the state's property insurance crisis. It's hard to explain in detail the catastrophic consequences of this for Florida homeowners and renters. The population of the state-run Citizens Insurance company is increasing by thousands every week. Every week it seems there are more insolvent property insurance companies, which will result because of what's called the guarantee fund in surcharges on existing homeowners insurance policies to pay the claims of these insolvent companies. The legislature also failed to deal with condominium issues that arose in the context of the Surfside collapse. There were proposals to for stricter inspection standards, increases in condo association reserves for repairs. None of those were adopted, but again, that could be the subject of a special session. And the issue of Medicaid was not addressed. As I said before, this is a joint federal state program. It takes up about a third of the state's budget. It provides health coverage for 5.1 million Floridians, about 20% of our population. The Medicaid program was deliberately expanded during the public health emergency declared by the president. When that public health emergency ends, there will have to be what's called eligibility redetermination for a number of the Medicaid recipients, and that is going to have catastrophic cost consequences in the context of the state budget. Finally, legislation to change the state bird from the mockingbird, which was established as a state bird in 1927, did not pass. The legislature did authorize 24-hour-a-day alligator hunting and designated strawberry shortcake as the official state dessert. So with that, we'll turn it over to Alex and Whit, and I look forward to the more interesting part of this program, which is answering your questions. So thank you very much, Whit and Alex.
Thank you, Lester. I'm going to go over just a few of the bills that we had been following that actually died before we get into the overview of what actually passed. So I'm not going to go over each one of these. I'm just going to point out some highlights. So a bill that would have required local government to prepare a business impact estimate before passing an ordinance did not pass. This was part of a pair of bills that focused on regulatory impacts on businesses. This one failed, but as Lester mentioned earlier, Senate Bill 620, which deals with business damages, did pass, and we'll talk about that in a few minutes. The bill that would have required local governments to adopt residential infill development standards didn't pass. Vacation rental didn't pass. Fracking didn't pass. One bill that we were interested in and was supporting was the Main Street Historic Tourism and Revitalization Act that would have provided a tax credit for historic structure rehabilitation. That bill didn't pass. The Florida Trust is going to, I believe, try again next year, and we'll be having an article about that issue in the upcoming issue of Florida Planning. A number of other bills didn't pass, as Lester said. Senate Bill 398 and House Bill 157, which would have capped the use of Transportation Trust Fund monies for public transportation projects at 25%, did not pass. Right now, it just says a minimum of 15% needs to be used. This would have capped it at 25%, and that did not pass. Then there was a bill that would have repealed the preemption of tree pruning and trimming and removal on residential properties. That didn't pass, but there was another bill, Senate Bill 518, that did pass that adds clarification and definitions to this existing preemption, and I'll touch on that in a few minutes. A number of others, they were trying to preempt the regulation of home kitchen operations like they did with cottage home-based businesses and cottage businesses. The bill that would have required comp plans and plan amendments that were on property within 2 miles of the Everglades protection area didn't pass. The bill that did raise some concerns when it was first filed, which would have allowed impact fee credits to be transferred to any zone in the same county, did not pass and actually was never heard in committee. And then just a couple of other bills, one of which would have limited constitutional amendments that were proposed by Citizen Initiative would have limited them to only dealing with procedural subjects or governmental structure and no other issues. That did not pass. So what did pass? There were a number of bills that passed that we followed and were interested in. The first one is Senate Bill 620. This was, like I said, the second part of the pair of bills that dealt with local business protection. This one creates a mechanism for a business owner to recover business damages. It passed the Senate 22-14, and it passed the House 69-45. So under this bill, a business can claim business damages from a county or municipality if the county or the local government enacts an ordinance or charter that causes the business to lose at least 15% of its profit on a per location basis, and if the business has been in the jurisdiction in operation for the 3 years preceding the enactment or the amendment to the ordinance or charter. Damages are limited to the present value of the business's future lost profits for the lesser of either 7 years or the number of years the business had been in operation before the ordinance had been enacted. And it does not apply to anything that is under an eminent domain proceeding. So you can't do like double recovery, anything like that. Now it does have some exemptions for when a local government is not liable for business damages. When the bill was originally filed, the exceptions were limited to the top 3 bullets: complying or authorized by state or federal law, an emergency ordinance, a temporary ordinance, and then there was another bullet that said something if it was increasing economic freedom. I'm not sure what that meant, but that was the 4th bullet. And then through the legislative committee process, the rest of these exceptions to this were added. So if the ordinance or the charter is enacted to implement, things related to 163, to growth policy, planning, land development, zoning, things relating to the Florida Building Code, the Florida Fire Prevention Code, if it's required to implement a contract, like you might have gotten a contract from the federal government, if it's related to issuance or refinancing of debt or a budget amendment or to procurement, or to promote, enable, or facilitate economic competition, then the local government would not be liable for any business damages. So it lays out a process for how a business would go about trying to claim damages. And basically, once the ordinance or charter is effective, then within 180 days after that, and at least 180 days before the business wants to file an actual legal action, the business has to present a good faith offer, and it has to have specified documentation, which is laid out in the bill, of what it thinks its claim for business damages is. And then the local government has, within 120 days, they have to accept, reject, or make a counteroffer. And that counteroffer could include their willingness to grant a waiver to the application of whatever the provision is. You have a year, if the claim isn't settled, you have a year to file an actual legal action, and the court can give attorney fees and costs to the prevailing party in that action. Now, if you amend an ordinance or a charter provision after the effective date of this bill and somebody wants to make a claim because of that amendment, they can only make that claim to the extent that the language that was amended is the cause. They can't go back to the original ordinance or charter provision. It can only be based on what was amended. So the bill does allow local governments a way to also cure the liability, so to speak. So within that 120-day period that they have to review the offer that was submitted by the business, there is no liability if they repeal the ordinance or the provision. So they just come and appeal it. They go back and they amend the provision that makes it basically the way it was before the claim arose, or they go back and amend it so that it doesn't cause the reduction of the 15% in the business profit. They can grant a waiver of the ordinance or the charter provision to the business. So if within that 120 days they do one of those things, there is no liability. With respect to an ordinance, within that 120 days, they could publish notice of its intent to repeal or amend the ordinance. So they didn't actually amend it, but they published the notice of their intent to repeal or amend it. And then within 30 days of that notice, they do, they go back and they return it to its previous form. They amend it in a way that gets rid of the loss of the 15% of the profit, or they repeal it. And then with respect to a charter provision, the county within that time period can provide notice of its intent to amend or repeal the provision. And then within 90 days of the publication of the notice, if the charter provision is amended or repealed in a way that gets rid of the issues, then there would be no liability. So this applies only to ordinances or charter provisions enacted or amended on or after the effective date, and the effective date is in the law is upon becoming law, which means when it's signed, or basically when it's signed by the governor. It had not been submitted to the governor as of yesterday. So the next bill that I want to talk about is House Bill 423. This is building regulation. There's a number of things in this bill, but there's two parts of interest. One that deals with the certain demolition permits, and then the other part deals with the local review of certain building permits. And this was passed unanimously in the Senate and in the House. So the first part of the bill that I want to touch on is basically dealing with demolition permits for single-family residential structures that are in hazard areas. So this creates a section that says local government can't prohibit or restrict a private property owner from getting a building permit to demolish his single-family residential structure if it is in the coastal high hazard area, the moderate flood zone, or the special flood hazard area according to the flood maps, if the lowest finished floor elevation is at or below base flood elevation, and if the permit applies with all applicable Florida Building Code, fire, life safety codes. So based on the legislative staff analysis, apparently there had been an uptick in permits to demolish older single-family homes, particularly in South Florida, to build new single-family homes. And some local governments had adopted regulations that would affect the ability to get the demolition permits. And I think that that was the rationale behind this bill. The application for the demolition permit can only be reviewed administratively for compliance with these codes, for the building code, et cetera. And it can't be reviewed on the basis of anything else. You can't add any additional land development regulations or public hearings onto these applications, and you cannot impose any additional regulatory or building requirements on the new structure that would not be applicable to a similar vacant parcel. Now, these provisions don't apply to a structure on the National Historic Register, a single-family structure that was designated historic by local, state, or federal government on or before January 1 of this year, or a privately owned structure that's designated historic after January 1 of this year by an entity with consent of its owner. So the other part of the bill deals with building permit applications to local governments, and it says that a local government can only make 3 requests for additional information from an applicant applying for specified building permits identified in the section on the slide. And basically among the building permits that are identified in that section are included non-residential buildings less than 25,000 square feet and residential units other than a single family unit and multifamily residential units not exceeding 50 units. So for those types, there are some, there's a new requirement. You can only make 3 requests for information about that. It does lay out some time frames for local government to review that additional information. It provides that if the applicant thinks that the request isn't authorized by ordinance or rule or some other form of authority, then the applicant can ask the local government to just move forward and process the application. They're just not going to answer any other questions. And it does require that prior to making a 3rd request for information, the local government has to offer to meet with the applicant to resolve the outstanding issues. The effective date of this, it would be July 1st, 2022, and it had not been submitted to the governor as of yesterday. The next bill is Senate Bill 1380. This deals with real property rights, and I will say I'm not an expert by any stretch of the imagination on this. There's a couple of interesting parts to this, but this deals with basically cleaning up your title, and it basically what the bill did was it modified the definition of covenant or restriction to include agreements or limitations that were a condition of a development permit. And it adds covenants, restrictions, zoning requirements, and development permits to the list of things that can be extinguished by this Marketable Record Title Act. But what it doesn't do is it doesn't delete or eliminate the underlying comp plan amendments, the zoning ordinances, the land development ordinances, those things. It doesn't delete those underlying plans or ordinances. And it doesn't delete any covenant or restriction that says on the first page of the document that it was accepted by a government entity as a condition of a comp plan amendment or a zoning ordinance or a land development regulation. So if it says it on the first page of the document, it would not be extinguished. And it allows somebody, a way for people to file a notice with the clerk to preserve an interest if they are afraid that their interest is being extinguished. But the other part of the bill that raised some interest was that it prohibits a county or municipality from enacting any ordinance or regulation that would restrict or prohibit the owner of a private parking facility from establishing rates and fees and issuing fines. Any ordinance that a local government has right now that does something like that is a violation of the section and would be null and void. But there were some changes that came through the committee process. The rates and the rules on fees and fines and rates and that kind of stuff have to be clearly visible to the people parking. And if you issue an invoice for parking charges and you're the private parking facility owner, that invoice has to include a statement that the invoice is privately issued, is not issued to by a governmental authority, and is not subject to criminal liability. I think there was some local governments that were concerned that private parking facilities were establishing or sending out tickets and people were getting confused as to whether the local government was doing it or whether it was the private entity. This would become effective upon becoming law, and it still had not been submitted to the governor yet. House Bill 749, dealing with legal notices. This bill was passed in the Senate 26-13, in the House 79-40. It deals with legal and official advertisements, and basically it allows a local government the option to publish legal notices on a publicly accessible website that's owned by the county or designated by the county, instead of being in a newspaper if the cost is less than the cost of publishing a newspaper. It requires the governmental agency, if at least 75% of its population is located in a county that has a population of fewer than 160,000, before you can publish legally required advertisements and notices on the county website, you have to hold a public hearing and determine that your residents have enough access to the internet that they can actually access the website. And it does require notice at least once a year in a newspaper of general circulation, basically to let property owners know that they can still receive advertisements by first-class mail or email if they register their name or address or email address with the governmental agency. If you are a special district that covers more than one county, then you have to do it on the publicly accessible website of each county that you cover. The effective date of this would be January 1 of 2023, and it had not been submitted to the governor as of yesterday. So then, as I said earlier, Senate Bill 518, which was dealing with the tree trimming legislation, was passed, and what it does is it adds definitions and qualifiers to the existing provision. If you remember, this was originally passed as part of House Bill 1159 in 2019, and it currently states that local government can't require a notice or an application or a permit or a fee or mitigation for pruning or trimming or removal of a tree on residential property if the property owner obtains documentation from a certified arborist or a landscape architect that the tree presents a danger to persons and property. But it didn't define what residential property was. It didn't necessarily define what the documentation meant, and it didn't really define what danger was. So this bill basically changes the test to say that you can't require the notice or the fee or whatever if you get the documentation from the arborist that's certified by ISA, which is the International Society of Arboriculture, or Florida licensed landscape architecture, that the tree poses an unacceptable risk as opposed to a danger to persons or property. And it defines what documentation is and says it's an on-site assessment that's done with the procedures laid out in this manual, and it's signed by the arborist or the landscape architect. And it also adds a definition of residential property to say it's a single-family detached building that's located on a lot that is actively used for single-family residential purposes. So it's not a lot that's vacant. It's a lot that is actively used for single-family residential purposes. And it's either a conforming use or a legally recognized non-conforming use. So it helps narrow down the definition of residential property for the purposes of this these provisions. And it defines unacceptable risk to say that there's apparently these tests in this best management practices, this tree risk assessment. And if removal is the only way that you can get the risk down to below moderate, then that's considered an unacceptable risk. The effective date of this is July 1, 2021. And Lester, if you have anything to add on any of these bills as I go through, please feel free. He's muted. Lester, I think you're muted.
You're unmuted. Go ahead.
I would just add on the tree removal bill, that we submitted a letter and some suggestions on that to the appropriate committees and work closely with local governments to improve a bill that was vague at best at the start.
The next bill that I want to talk about is House Bill 1411, floating solar facilities. Last year, if you remember, the legislature passed Senate Bill 896, which said that a solar facility was a permitted use in all agricultural land use categories in the unincorporated areas. I mean, in the incorporated areas and in all ag zoning districts in the unincorporated areas. So this year they came back and have stated that floating solar facilities are permitted use in all appropriate land use categories, and it requires the local development regulations to promote the expanded use of these facilities. So basically, this is a floating solar facility is just a solar facility that's located on a wastewater treatment pond, an abandoned lime rock mine area, stormwater treatment pond, a reclaimed water pond, or other water storage reservoirs. So it requires the solar facilities to comply with the setback and the landscape buffer area criteria for similar uses in the agricultural districts. It allows the county or municipality to adopt ordinances for specifying buffer and landscaping requirements, but it can't exceed those that are required for other similar solar facilities. And it does prohibit the construction of these floating solar facilities in an Everglades agricultural area reservoir project if the local governments that are involved with that project determine the facility will have a negative impact on that project. And it requires the Office of Energy within the Department of Agriculture and Consumer Services to develop and come up with recommendations by the end of this year to provide a regulatory framework to private and public sectors that want to implement these solar facilities. The effective date would be July 1, 2022, and it hadn't been submitted to the governor yet. So agritourism was another issue that we were following, and it made some amendments to the existing agritourism statutes. It removes a requirement that agritourism has to be a secondary stream of revenue for a bona fide agricultural operation. So it doesn't have to be a secondary. It could be, more important than that. It says that you can't deny or revoke an agricultural classification because somebody constructed or altered a non-residential farm building or some other facility that was used to conduct agritourism activities, as long as the building or the facility is an integral part of the agricultural operation, the land stays considered to be agricultural in nature, but those buildings and facilities have to be assessed at their just value and added to the agricultural assessed value of the land. That's would be effective July 1, 2022, and still has not been submitted to the governor. And then this was another bill that Lester alluded to, Senate Bill 882, and this is a bill that requires water management districts in cooperation with their local governments to come up with a list of critical wetlands that they're going to acquire through the Land Acquisition Trust Fund. And in order to figure out whether a wetland is critical, they would look at the ecological value of the wetland, the effect of the wetland on water quality and flood mitigation, the ecosystem restoration value of the wetland, and the inherent susceptibility of the wetland to development. So looking at all of those things, they would come up with a list of critical wetlands. They would be required to notify the owner of any property that they want to include on this list before they adopt or amend the list. So they would have to notify the owners, and the owners can have their property removed from the list at any time if they submit a letter to the water management district stating they want their property to be removed, and they identify it in a way that the governing board can know what that property is. And then if they get a request like that, then the water management governing board at its next scheduled meeting has to approve removal if it meets those notice and identification requirements. And then the water management districts that have an annual strategic plan have to include the list of critical wetlands in such a plan. The effective date of this would be July 1. And then I believe I am turning this now over to Whit.
What clued you in? I'm going to give Alex a little chance to rest her voice for a few minutes and cover some other bills. House Bill 7053 is a bill that would create a panel, actually establish a statewide Office of Resilience within the Executive Office of the Governor. And some of you may know that this was attempted in the past years and never really gained any traction. So this is a good development, I believe. And what it does is it requires that this office be established to be headed by a chief resilience officer appointed by the governor and serves at the pleasure of the governor to coordinate all these different mitigation and resilience activities and to be a conduit between the federal, state, and local government stakeholders. This creates a requirement for the Florida Department of Transportation to develop a resilience action plan for the state highway system based on forecasted future events and current conditions. And that's required to be accomplished by June 20th of 2023. And that includes things such as operational enhancements, design strategies, enhancing partnerships for collaboration across multi-jurisdictional areas. In addition to that, the bill has various provisions relating to resilience funding and planning, authorizing the Resilient Florida Grant Program with funds for pre-construction activities and projects that are submitted for inclusion in the statewide flooding and sea level rise resilience plan by municipalities with a population of 10,000 or fewer and counties with a population of 50,000 or less. It defines the term pre-construction activities and authorizes special districts that are responsible for the management and maintenance of inlets and intercoastal waterways to also develop similar plans. And the effective date on this one is July 1st, 2022. It hasn't been submitted to the governor yet. And you can see that there's some funding requirements here in terms of $100 million cap on funding proposed each year in the plan with a minimum threshold of $100 million. Okay, the next bill that I'll cover is residential development projects for affordable housing, Senate Bill 962. This was a bill that I paid a lot of attention to during the session because it was another preemption of local government planning responsibility to preserve industrial and employment land, for instance. What this does is it amends Florida statutes dealing with affordable housing that states that parcels that are zoned for commercial or industrial use, local approval may include a mixed use residential development project if 10% of the units are for affordable housing and the sponsor of the project agrees not to apply or receive funding under the state apartment incentive loan program. So it doesn't preclude all potential affordable housing funding sources, but this particular one is precluded. The provisions are self-executing, so they don't require the local governments to adopt a special ordinance or any regulation to implement this provision. What I find interesting is just a couple of years ago, we saw the legislature pass House Bill 1339, which allowed for affordable housing to be built on industrial or commercial areas if enacted by a local government. And this to me kind of completely undermines that because now you're competing mostly fair market value mixed-use developments against affordable housing, and I think we know who generally wins out on those kinds of projects. This will be effective upon becoming law, but hasn't been submitted yet to the governor. Next slide. School concurrency also had some provisions passed by the legislature, amending statute 163. This provides that concurrency is satisfied when the developer has a written, legally binding commitment to provide mitigation. The current language requires developer to execute a commitment. And after receiving the commitment, the district school board has 30 days to notify the local government that capacity is available. If proportionate share mitigation is not directed toward school capacity improvements identified in the 5-year educational facilities plan that satisfies the demands created by the development, the mitigation must be set aside and not spent until such an improvement has been identified. So this is effective also July 1st, 2022, and we're waiting for it to be sent to the governor. Local tax referenda requirements. So the legislature periodically tries to tie the hands of local governments in passing various local measures for revenue. This requires that referenda authorizing certain optional local taxes be held during a general election. This has already been done for certain sales tax referenda as well. And you can see the ones that are affected here. And I'm not sure if Alex or Lester can chime in on this, but I had a question about whether this, some of these now are decided by a majority vote or a super majority vote of the Board of County Commission. And I wasn't clear if this now changes that to require that they be citizen referendums.
I don't know the answer to that. I'll have to look into that. If anybody has any questions, you can contact the office here and I'll get an answer for you.
Okay, we'll follow up on that one. And just a reminder that if anybody does have questions, I do see a couple of questions already in the question box. Just go ahead and type your questions into the question box and we'll answer those at the end of the presentation. Next slide, please. All right, one that got a lot of attention in the media was the Individual Freedom or House Bill 7. This was a bill that emerged after there were several competing bills. This one deals with unlawful employment practices and provides that subjecting any individual as a condition of employment, membership, certification, licensing, credentialing, passing an exam or training or any other instruction that espouses, promotes, advances, you can see all those words there, to believe certain concepts constitute discrimination based on sex, color, or national origin. This amends Florida statutes to provide that it constitutes discrimination on those various bases that subjects a student or an employee to training that compels them to believe certain specified concepts. This is essentially the anti-critical race theory bill, or the Stop Woke Act, as Lester mentioned earlier. It expands the requirements related to the teaching of the history of African Americans. And as with the House Bill 1557 or the Don't Say Gay bill, what's really important here is maybe not all the words that are on the page, but sort of what's implied and some of the vagueness in the legislation. One of the things that happened was after the bill was passed by both the House and the Senate, there was an amendment during the budget process that a budget conforming bill that wasn't included that enables the enforcement of this bill to be carried out with cutting of performance funding for state universities. So if somebody feels that a university program has overstepped its bounds, for instance, then they can complain to the legislature, they can complain through the courts, and a legislative committee could actually have a finding that would restrict funding in a subsequent year. So for those reasons, APA Florida sent a letter yesterday to the governor requesting that this bill be vetoed. Not because we're, trying to advocate for critical race theory or anything like that, but there's a chilling effect here on the ability for planners in the planning profession, and certainly university programs training planners, to be honest and clear in the teaching of issues related to equity and social justice, which is part of the AICP Code of Ethics.
Yes.
And just some of the vagueness in this bill is what was troubling to us. Lester, something to add?
Well, I think you made an excellent point, and I was hoping that you would mention the letter, which we, as you point out, we have transmitted to the governor, citing the AICP Code of Ethics.
And really just, we had a good discussion with the executive committee last week, and we really just wanted to highlight as well that the bill is vague, that it's hard to determine when some of these actions happen, and then the remedy is not necessarily through the courts and a trial or some other finding by a judge, but could be a finding by a committee of the legislature. And that's particularly troubling as well. So just something that was a little disturbing. We don't write too many veto letters. This is the only one we submitted this year. I think last year was just 2. So, we try to be judicious in which fights to pick. Next slide, please. And back to you, Alex.
Back to me.
All right.
Let me get to the next slide. So I'm just going to go over quickly some other bills that passed, just to highlight them before we go to questions and answers. The airport funding bill has been submitted to the governor. He has till April 12th to sign it. This law expands what airports are eligible for DOT funding of the non-federal share of the projects. Right now, it says it's limited to airports that have no scheduled commercial service. This bill would expand it to general aviation airports or commercial service airports that have fewer than 100,000 passenger boardings per year. So it allows DOT's funding to apply to additional types of airports. There was a bill, Senate Bill 856, that would allow private providers to do inspections for on-site sewage treatment and disposal systems. There's a bill, Senate Bill 494, that deals with creating Gopher Tortoise recipient sites. And also, I'm not sure this was part of it, but it prohibits a local government from creating a public bathing beach or swim area in the marked channel of the Intercoastal Waterway or within 100 feet of the marked channel. None of these have been submitted to the governor as of yet. Senate Bill 442, which deals with land authorities in counties that have one or more areas of critical state concern, would allow land authorities to assist those counties in the administration of grants awarded to the counties for residential flood and sea level rise mitigation projects. House Bill 965 provides for the development of water enhancement areas, and those would be available to be used by government entities. Government entities would be able to buy credits and then use them for offsite mitigation, regional treatment. There was Senate Bill 758, which made a number of changes related to charter schools. One of interest was that charter schools cannot be subject to a land use regulation that requiring a change to a comprehensive plan or requiring a development order or a development permit. Then, as Lester said, the House Bill 105, which was the Florida Clean Air Act that allows counties and municipalities to restrict smoking in public beaches or parks, but you can't restrict the smoking of unfiltered cigars. So those are kind of the bills that we're following. So I guess we'll open it for questions. I put on this last slide. This is where this webinar is 1.5 CM credits. You can claim 1 CM law, and that's the event number that you can log your CM credits under. So I guess we will move to questions. And let me find the questions. I'm happy to.
We have a few questions here. I'm looking at a few of them. One is from Stephen Benson. Was there anything relevant to pedestrian safety that passed? And I think I can take a stab at that. Stephen, every year there's a vulnerable road users bill that's filed. There's also bills that we were tracking that were filed related to the move over law, things like that. And none of these bills ever seem to find a hearing in committee. So again, this year, I'm not aware of any bills specifically related to safety that passed. You may remember that for the last 3 years until this year, Representative Fine was trying to remove the rectangular rapid flashing beacons and mid-block crossings. That was not filed this year, so I guess we'll claim that as a little bit of a victory. But none of the safety bills that would have increased the penalties and fines for people who are found guilty of either leaving a scene or injuring or killing somebody, or the move over law, none of those gained any traction this year.
Whit's been very active in helping us and therefore helping the legislators understand the implications of some of these pedestrian safety bills.
Yeah, hopefully we can, I mean, if they're serious about safety, we've got a couple of bills that get filed every year that we'd like to see get some traction. So we'll work on trying to advance those a little bit. Let's see, the next one is regarding legal notices, reference the county website. Is this applicable to cities or would they need to use a county website?
So my understanding on the way the bill works is it defines something called a publicly accessible website, which is hosted by the county. And then local governments, whether they're special districts or municipalities, would have the opportunity to post their notices on that website. So it does apply to municipalities, but they would use a county website, not their own.
That's my understanding too.
All right, let's see, the next question, will you be sending out the presentation slides after the webinar? Alex, yes.
Yeah, we'll send out a PDF version of it to everybody that registered.
Okay, I like questions like that. They're easy to answer.
Exactly. Just find those, Whit.
Right. This is one from Eliza Giuliano. How do you think Senate Bill 962 will be implemented? Will local governments slow down on creating mixed-use zones since they now have this outlet? You know, I'll try. That's a good question. Frankly, this bill we heard through the grapevine was targeted at my county because we denied an industrial development on a vacant piece of property that's been vacant for a while that proposed mixed-use development, and they had amazingly a 10% affordable housing threshold. So what it does is it precludes countywide planning authorities like my agency from denying development like that, but it leaves it up to local governments to implement these provisions, and it doesn't specify that the 10% threshold is a maximum. So that could be, that's a minimum. So the city of St. Petersburg or city of Orlando or any other city or county could say, you know what, we think there ought to be a 50% threshold. So that could happen. We support mixed use development, but we also have this goal of preserving industrial and employment land in a compact built out county. So I think it probably is not as much of a challenge to counties that have, or areas that have a lot of room to develop and can put together a master plan and can come up with a good site plan. But for us, this really robs Peter to pay Paul. I don't know if anyone wants to add any other aspects to this. Thomas?
Yeah, I think this is a great question, and I don't know the direct answer that Eliza's asking, sort of what will local governments do, but I would have advice for any local government, and that is, the bill says it's self-executing, but it also uses the word may to suggest that the approval is discretionary. And so that creates a real conundrum for a local government is going to be considering these proposals in a quasi-judicial hearing. Now you've got the sense that they have discretion, but a state law that says that whatever rules they have prohibiting residential development in an industrial zone or land use category are not applicable. And so that has a potential to create a lot of conflict in the code. So I would think that for a local government to stay in the driver's seat over whether it approves or denies a proposal for this kind of development, it's going to need some policies specifically related to this kind of development. So my advice to local governments would be decide what criteria should apply to proposals for residential development in your industrial categories. And you could include criteria like, are we retaining enough land with an industrial zoning designation to provide for our foreseeable economic development, right? That might be a very reasonable condition you would have for approving this kind of development. But if that's not in the code, I think it creates a lot of ambiguity. You know, I wouldn't know what the answer would be if it were litigated.
All right, thank you for that. I skipped over a few questions, so I'm gonna go back up to the top. For Alex, is any idea why the Main Street Historic Revitalization Tax Bill did not pass?
I think it just kind of ran out of time. It was, and Lester, you can help too. I know that one, I forget which side, it might have been the Senate side. I can look it up in a second, but on one side it was moving along and we thought it was going to pass, and then I think it just kind of lost steam. So they're not giving up on it. Like I said, I think they're going to try to file it again next year and, you know, come up with another strategy of how to push it over the edge.
It's a great description of what happened. Going back to our original slide with all those 3,800 bills, the funnel gets very, very tiny at the end.
Let's see, next one, tree removal bill effective 2021, not 2022. I think
No,
we
it's
mean
2022.
Right.
If I made an error in the slide, I'll correct it before it goes out.
Okay. And then let's see, could you repeat the charter school bill?
758. Senate Bill 758.
Yeah, I'm not sure. The question just says, could you repeat the charter school bill? Could you do a?
Can you go back to your slide?
Yeah.
Maybe.
Yep.
Yeah, maybe just go back to that and hit the high points again.
It has a whole bunch of changes to charter schools, but the one that I thought would be of interest to our members was that the charter school isn't subject to any land use regulation that requires them to get a comp plan amendment or a development order or development permit that would not be required for a public school in the same location. So you can't ask the charter school to do something that you wouldn't require the public school to do, is the way I read it. Thomas, you can maybe add.
That was my reading as well.
Yeah.
Cindy Dittmer had a follow-on question about 962, about the commercial industrial zones. She asked if it undoes, is that a word, the flexibility provided by the previous House Bill 1339. And I don't think it does. I think it gives one more option. So this is why I felt like it was kind of a dumb bill. We had House Bill 1339 that allowed for affordable housing projects to be built in those areas. St. Petersburg has actually put a nice little framework around that, which it enabled local governments to frame that decision for their own respective bodies. What this does is it now opens it up to mixed use developments that only 10% has to be affordable. So I think it kind of undermines 1339, but it doesn't preclude it. So 1339 is still part of the law. It just gives you one more option. And then let's see, Penelope Cruz has a question about Senate Bill 518. Does this clear up lawsuits regarding mobile home parks being residential?
A mobile home park would meet the definition of residential under the bill, but that definition only applies to this narrow area of tree removal. So I'm not sure exactly the scope of the question. In terms of tree removal, yes, mobile homes would be residential. But any sort of broader or other understanding of mobile home parks as residential, I don't think this would affect.
And Bill Wharton has a question. What were they trying to do with the additional revision to 518?
My understanding was that there were issues where people were interpreting this if it was just zoned for single family. It was a single family lot that didn't have a house on it, that they could go in and start taking the trees down and clearing under this. And so there was a desire, I know it was the League of Cities was interested in trying to get some better definition so it wouldn't turn into, you could just come in and clear cut, a lot. It had to be an active residential property that was in danger. And now, so that's why they were trying to add the definitions and to trying to rein in the scope of how the law was being implemented.
Rein in the scope and provide a bit more clarity, yes.
Right.
Okay, and the tree removal bill is Senate Bill
518.
518. Okay. All right, I think those are all the questions that I see on the box, unless anybody else has any additional questions. We've got a few more minutes. Not seeing anything else in there. Well, I want to thank everybody for joining us today over your lunch. Hope you enjoyed a nice lunch while we talked. And I want to thank Thomas for joining us and helping answer some questions. I think this is a great format and glad you could be here. And Lester, thanks always for all your help. You're a shining light for us in Tallahassee and really help us understand the inner workings of committees and the legislators and have, I know you've helped one of my board members and me and some others really sit down and talk to the right people at the right time when we need to have those conversations. So thanks for all you do. And Alex, great job as always. Thank you very much. And I would encourage anybody who's interested in the Legislative and Policy Committee, either following it or serving, please send an email. You can reach me or you can reach out to Alex, and we'll be sure to follow up and get you engaged.
And can I put a plug in that for non-legislative related activity, the call for presentations for our annual conference, which will be held in Orlando, has been extended till the 5th. So if you are interested in doing a presentation and you haven't had quite the time to finish it, we gave you a few extra days. So I encourage you all to go online and look at what the criteria is and submit some sessions. We'd love to hear your stories at the conference.
All right, well, thank you everybody for joining us, and we'll sign off.
Thank you, sir.
Thanks for having me.